advancements in criminal justice system. I feel honored to introduce you among this online gathering. Sri Sanjay has completed BSc Honours and LLB from Delhi University and LLM from Kurukshetra University, Haryana. He has joined Delhi Judicial Service in the year 1992 and promoted in Delhi Higher Judicial Services in year 2003. He has posted and worked in different jurisdictions such as civil, criminal, land allotment committee, labor, etc. He is trained mediator and trainer under the aegis of Mediation and Conciliation Project Committee, Supreme Court of India, imparted training at the length and breadth of India. He has worked as Chief Legal Advisor to Delhi Development Authority, Head of Law Department under the Chairman of Lieutenant Governor and City of Delhi. Delhi Development Authority is the largest litigant in India. Sri Kumarji worked as First Registrar General, National Green Tribunal, the world's first adjudicatory forum. He has posted as Principal Judge, Family Court, East District, Karkaruma, Delhi. At present, Sri Kumarji appointed as Principal District and Session Judge, West District, Tis Hazari Court, Delhi. He is also a Fellow of Commonwealth Judicial Education Institute, Canada. Now, not taking much time, I'm handing over the session to Sri Sanjay ji. Sir, over to you.
Thank you. Good afternoon to all. So, I am not an expert or authority, because we say in law, nobody is master of law. We are all students. So daily we learn from each other. And whatever little knowledge I have on the topic of admissibility of electronic evidence, which is the present day very developing area in the field of law. And I just start. There is a perception. I can mix Hindi with the English?
Yes, certainly.
Okay.
Yes, sir.
जी, एक perception है कि जो कोर्ट में हम देखते हैं ना स्क्रीन पे, सीरियल्स में, मूवी में, कि कोर्ट में बिल्कुल वैसा जो है एक perception रहता है कि ऐसा ही होता है कोर्ट्स में. बट ऐसा नहीं है. कोर्ट्स का टोटली डिफरेंट प्रोसीजर है, डिफरेंट सीन होता है. और जैसा कि हम देखते हैं मूवीज में खास तौर से कि एकदम लास्ट में कोई आता है कि जज साहब मुझे सुनिए, और जो है एकदम से फिर जज साहब कहते हैं हाँ आइए आप. ऐसा नहीं है. वी हैव सेट प्रोसीजर, एंड इन दैट प्रोसीजर, in every civil case or in criminal case, we have to give evidence, and that evidence is governed by the Indian Evidence Act. And there are two kind of evidences which are recognized by the Indian Evidence Act. One is oral evidence. As I am speaking, suppose I witnessed something or seen something, then if it is an incident, if I come to the court and narrate the evidence, my statement or whatever I have seen, describe the scene or the incident, that is called oral evidence. And the other category of or kind of evidence is documentary evidence. That is the documents like sale deed, any agreement, any suppose will, or any other document which is in the form of a paper or some other form, these two kind of evidence generally produced or seen by the courts during the trial. जो भी मुकदमे की सुनवाई होती है, दो ही तरह के हम एविडेंसेस पे जो है वो इंस्पेक्ट करते हैं और उसी पे सारा जो हमारा मुकदमा उसी के ऊपर चलता है. तो prior to 2000 or prior to the modern development of new devices, computers, laptop, mobiles, and other electronic gadgets, it was simple for the courts for documentary evidence, how to take on record, how to analyze, how to admit documentary evidence. But now when the world has changed, these new devices have come into existence, and we don't have any provision how to deal with this situation. Now we are daily basis, we are exchanging our conversation through email. So if you take out an email printout and produce in the court, prior to 2000, it was a very difficult, there is no scope how to bring to the court as documentary evidence. So amendment was carried out in the Indian Evidence Act simultaneously with the existence of a new act, that is Information Technology Act, which came into existence in June 2000, and the amendment in the Evidence Act effected in October 2000. The legislature has introduced certain sections to deal with this situation. Section 65, capital A, and Section 65, capital B were introduced specially relating to electronic records. In addition to it, Section 45A introduced with regard to opinion of examiner of electronic evidence. And another section was incorporated, Section 22A, when oral admission as to contents of electronic records are relevant. So these provisions were introduced to deal with the situation where the evidence is in the electronic form or based on electronic record. The provisions came for interpretation before the Honorable Supreme Court, and how the journey started mainly, it was with the very famous case, that is the Parliament attack case, which was decided by Honorable Supreme Court in the year 2005. It is known as Navjot Sandhu alias Afsan Guru. In this case, the interpretation of Section 65 A and B for the first time came before the Honorable Supreme Court with regard to the electronic evidence which was produced by the investigation of agency during the trial with regard to the mobile data, the mobile calls exchange between the conspirators and the handlers. ये जो हम भी बात करते हैं जो डेली मोबाइल पे, ये हमारा रिकॉर्ड सर्वर्स में कॉल रिकॉर्ड प्रिजर्व, एवरीबॉडी नोज दैट, प्रिजर्व रहता है। तो जब भी कोई इंसिडेंट में रिक्वायर होता तो कंसर्न सर्विस प्रोवाइडर से इन्वेस्टिगेशन एजेंसी दे आस्क फॉर द relevant call records. So similarly in this case also the call records were produced, and Supreme Court held that the conversation, the call records which were produced during the trial, they are electronic evidence and can be admitted by producing the call record printout, and if any responsible officer of the mobile company comes to the court and gives statement that these call records were taken out from the server and the printouts are genuine, then they can be treated as electronic record produced from the main source as evidence, and on the basis of the oral evidence of the official, that can be admitted and proved by the investigation officer agency during the trial, and it was held the call records are admissible and proved by the investigation agency. However, the in this case, a very important aspect of section 65B was not interpreted as envisaged in the Evidence Act. It was said that as per earlier practice, as per section 62 of Indian Evidence Act, the call records are admitted or admissible before the court. However, this law remains in force and followed by all the courts. Now, after about 9 years, the same question again came before the Honorable Supreme Court in the case of Anwar PV versus PK Bashir, 2014. It was an election petition and the dispute with regard to the CD produced in the court. So in this case, again the Honorable Supreme Court analyzed and interpreted the section 65A and 65B and came to the conclusion that any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and section 65A can be proved only in accordance with the procedure prescribed under section 65B. Section 65B deals with the admissibility of the electronic record. The purpose of these provisions is to sanctify secondary evidence in electronic form generated by a computer. Here I will take a pause. Generally, there are two kind of evidences brought to the court in civil as well as in criminal proceedings. Suppose I have a sale deed and original sale deed, registered sale deed, if I produce in the court, it is called as primary evidence. So I have to do nothing. I have to produce simply the original sale deed before the court. So it is proved and admissible in the court. इसको माना जाता है और इस पर कोर्ट कहती है कि हाँ ये आपने ठीक साक्ष्य दिया है कोर्ट में कि ये सेल डीड से आप मालिक हैं, जो भी सब्जेक्ट मैटर है सेल डीड का. सपोज मान लीजिए मेरे से सेल डीड खो गई है और मैं उसे पेश नहीं कर सकता हूं, तो कानून हमें रियायत देता है कि मेरे पास अगर सर्टिफाइड कॉपी है उसे मैं कोर्ट के सामने पेश कर सकता हूं कि वो ओरिजिनल सी रजिस्ट्रार ऑफिस से मैंने सर्टिफाइड कॉपी ली हुई है, एज पर रूल्स इशू हुई है. तो इन दी एब्सेंस ऑफ ओरिजिनल सेल डीड आई कैन प्रोड्यूस दी सर्टिफाइड कॉपी एज secondary evidence. So the certified copy, which is not the original, but it is certified by the registrar office, is known as secondary evidence. And when it is admitted in the court, it is as good as the primary evidence. But now in the case of electronic evidence, as per section 65B, there is a procedure laid down how to produce the secondary evidence, secondary electronic evidence in the court, which would be admissible and relied by the court during the trial. For example, आज से 15-20 साल पहले जो हमारे कैमरास होते थे उसमें एक हम रील डालते थे और कोई भी फोटो क्लिक करते थे तो उसका फिर पॉजिटिव बनता था. और सपोज वो किसी एक्सीडेंट केस में या किसी और केस में हमें रिक्वायर्ड है, तो जनरली कोर्ट में हम जानते हैं कि एक वो नेगेटिव आता था और साथ में एक पॉजिटिव आता था. तो अगर हम पॉजिटिव उसका प्रिंट आउट कोर्ट में लाते थे तो साथ में हमें नेगेटिव देना पड़ता था. और हम कितने भी पॉजिटिव बना सकते थे उस नेगेटिव के. तो वो सिंपल प्रोसीजर था, पॉजिटिव बना के नेगेटिव दिखा के हम प्रूव कर लेते. तो खाली हम पॉजिटिव अगर प्रिंट आउट देना चाहे तो कोर्ट में वो मान्य नहीं है जब तक आप उसका प्राइमरी सोर्स नहीं दिखाए. लेकिन आजकल डिजिटल कैमरे आ गए, तो जब हम डिजिटल कैमरे से कोई प्रिंट आउट लेते हैं, फोटो लेते हैं, देन वी हैव टू फॉलो दी, इट इज नोन एज नाउ इलेक्ट्रॉनिक फोटोग्राफ, इलेक्ट्रॉनिक रिकॉर्ड से प्रोड्यूस किया हुआ फोटोग्राफ. देन वी हैव टू नाउ फॉलो the new rule, that is section 65B. उसमें एक प्रोसीजर है, उसको फॉलो करके हम कोर्ट के अंदर वो फोटोग्राफ को प्रूव कर सकते हैं जो कि कोर्ट के सामने मान्य हो. तो इसी तरह कोई भी इलेक्ट्रॉनिक गैजेट से, मोबाइल से, लैपटॉप से या सीडी कैमरा से, सीडी या कोई भी उसकी कॉपी बनाई जाती है या डॉक्यूमेंट प्रिंट आउट होता है, तो हमें वो दो तरीके से हम दे सकते हैं कोर्ट में. एक तो हम, मेरा जैसे लैपटॉप या मोबाइल है, आई कैन कम टू द कोर्ट एंड प्रोड्यूस द लैपटॉप एंड द कॉपी टेकन आउट एज ए प्रिंट आउट और फोटोग्राफ. दिस इज माई लैपटॉप, आई हैव टेकन आउट दिस डॉक्यूमेंट and this is the copy stored. जो हमारे उसमें डाटा स्टोर है उससे हम उससे प्रिंट आउट निकाल के कोर्ट में दिखा सकते हैं. सपोज वो कंप्यूटर मेरे पोजेशन में नहीं है, या वो कंप्यूटर किसी सिस्टम से अटैच है, जो पूरा सिस्टम हम कोर्ट में नहीं ला सकते, उस सिचुएशन में हम उसका प्रिंट आउट लाते हैं। तो वो कैसे कोर्ट में, अब इन द एब्सेंस ऑफ प्राइमरी सोर्स, अब हम सेकेंडरी सोर्स ला रहे हैं, वो कैसे हम प्रूव करेंगे कोर्ट में, और वो कैसे एडमिट होगा, एंड वो सेक्शन 65 में प्रिस्क्राइब किया हुआ। तो 65B, if I read out the conditions, it says, notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be a document. So the subclause 4 laid down the procedure. In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate a certificate doing any of the following things, that is to be, say, identifying the electronic record, containing the statement, and describing the manner in which it was produced, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, dealing with any of the matters to which the condition mentioned subsection 2 relates and purported to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities shall be evidence of any matter stated in the certificate. The simple reading says that if I take out a printout from any laptop or computer, then I have to give a certificate that this is the document taken out by me from my computer so and so, and give all details in the form of a certificate. The document taken out from the computer, laptop, or mobile, plus the certificate. Then only it can be treated as evidence and admissible in the court of law. Suppose a CD recording from a camera or CCTV system is taken out and produced in the court, then it is, as per section 65B, the person, the official who has authority, has to give a certificate that this CD is prepared from this CCTV system, and how it is produced he has to describe in a form as certificate. I hope I am clear.
Yes, sir.
Can't simply say कि this is the document taken out, print out, or taken out or prepared from the electronic device, and I am submitting in the court. That is not valid tendering of electronic record or evidence in the court. It has to be accompanied by a certificate as prescribed under section 65B. So this question arose in, I was referring to the case of Anwar. After that parliament attack case, because generally the certificates or the compliance of section 65B was sometimes there, sometimes not there. So there was all confusion with regard to compliance of 65B. So in this case, Honorable Supreme Court after considering the earlier judgment of Parliament attack, that is Navjot Singh's case, and concluded that the certificate as mentioned in the section 65B is mandatory. If a mandatory certificate is not produced along with the electronic evidence, that evidence is not admissible in the court of law. So it said in this judgment, it is said that the very admissibility of such a document, that is electronic record, which is called as computer output, depends upon the satisfaction of the four conditions under section 65B2 as I read out to you. It was further stated that and clarified that the person need only to state in the certificate that the same is to the best of his knowledge and belief. Most importantly, such a certificate must accompany the electronic record like computer printout, compact disc, video compact disc, pen drive, etc., pertaining to which a statement is sought to be given in evidence when the same is produced in the evidence. All these safeguards are taken to ensure the source and authenticity, which are the two hallmarks pertaining to electronic record sought to be used as evidence. The reason given is that electronic records, being more susceptible to tampering, alteration, transposition, etc., without such safeguard, the whole trial based on proof of electronic record can lead to travesty of the justice. So as we know कि these all जैसे hackers का हमें पता है वो कुछ भी hack कर लेते हैं, we can manipulate with the computer data, mobile data. So these safeguards are provided under section 65B in case any electronic evidence has to be produced in the court. So after 2014, again situation changes, where in a case the Supreme Court held that case is Shafi Muhammad's case, where Supreme Court said that certificate can be relaxed. The condition to give mandatory certificate can be relaxed. So again, the interpretation of admissibility of the electronic evidence was again because of two different opinions. So now the situation arose, which judgment we have to follow. This judgment came in 2018, where some relaxation has been given, that the court can relax the condition of mandatory certificate. Then a 3-bench judgment studied all the previous judgments in the case of Arjun Pandit Rao Khotakar versus Kailash Kushan Rao and others in the year 2020. In this case, the full bench, that is the 3 judges bench, they have gone through the genesis of section 65 A and B and all the judgments pronounced by Honorable Supreme Court, the Navjot Singh case, the Anwar case, Shafi Muhammad case, and laid down and clarified and clear all the confusion in interpretation and applying the section 65 A and B in the court of law. According to this judgment, production of certificate under section 65B(4) is mandatory, but only in cases of secondary evidence. That is where primary evidence is not led, original is not produced, then section 65B(4) is mandatory. In case primary evidence is led, then 65B certificate is not mandatory. Suppose a witness along with his electronic gadget step into the witness box, then there is no need of a certificate as provided under section 65B. So this judgment now clarifies and laid down the law that in case of electronic evidence, section 65(4), section 65B(4) certificate is mandatory either in civil trial or criminal trial. In addition to this, in this judgment, the Honorable Supreme Court points out that certain directions are required for preservation and production of electronic records by the service providers. So the Supreme Court directed the service providers, cellular companies and internet service providers, that under IT Acts, the rules shall be framed under section 67C until that time the cellular companies and internet services providers are required to follow the directions as laid down by Honorable Supreme Court in this case. So the given time, I shared with you the admissibility of the section 60 of electronic evidence as per the amended provisions of Indian Evidence Act, section 65 A and B, and how the journey started, and now the law is laid down in the case of Arjun Pandita case, which is the law of the land at present, and we are all following the directions and the law laid down by Honorable Supreme Court, full bench in this case. So, shall I proceed to the other, that DNA, how the DNA profiling and DNA test is now we are.
Yes, sir. We have 10 minutes more if you want to.
So this is another area where the forensic science is playing very important role for in both civil and criminal trial. That is the DNA. I think all experts are there. They know the basic what is DNA, how it is collected, how it is scientific. The scientific, we can say, point of view of the DNA. So I will share the how courts are and the legislature is how dealt with this very important DNA, importance of the DNA in the criminal trial or investigation or civil cases. In CRPC, in the Code of Civil Criminal Procedure, there was an amendment in the year 2005, and Section 53A was added, where in the case of rape or attempt to rape, the directions given to the investigation agency to carry out DNA profiling of the accused. Prior to it, the law was that one cannot be compelled to give blood sample or cannot be compelled for DNA test, because Constitution safeguard that right to every citizen. One can't be a witness to his own self-incriminating evidence as per Article 20. One cannot be asked to give evidence against himself. And second is the privacy under Section Article 21, the right to privacy. So, however, the Supreme Court developed the proposition and given certain relaxations where court feels like that it is necessary for giving the it is necessary for the fair trial or justice, then one can be directed to give the blood samples, or the court can direct for conducting the DNA test, especially in the cases of dispute of paternity, property inheritance sometimes, and very important in criminal trials, because in criminal trials it is very, very important piece of evidence, because after DNA test, if the we can say proposed accused or the accused facing the trial is left with some, we can say, the hair or some other body, some part or some something was detected by the forensic experts, and DNA test has been carried out which link with the commission of offense of the proposed accused, then it can be conclusive evidence before the court during the trial. So I also came across that the government has been making attempt to give the statutory status or the make a uh, rule or law of the DNA technology. There is a bill introduced, I think, in the year 2018 and 19. It is called the DNA Technology Use and Application Regulation Bill 2019, which is giving the statutory status to the DNA, which is now very essential as per the object and the reason set for introducing this bill. It is very comprehensive bill, but I think it has also been examined by the standing committee of the parliament, but still it has not been passed by the houses. It talk about the constitution of DNA regulatory board and laboratories, DNA laboratories, and their standard, how they can maintain the technical aspect and how they run the to a optimal standard the DNA laboratories. Then a data bank be prepared of DNA, which will help. Like in Western world, they are having DNA data bank. If some offender or some habitual offender is there, we can find out easily from the database that DNA database. But still, I think it is pending for consideration of the parliament. The DNA test is also very important evidence nowadays, and especially now we can see the increase of the child abuse, especially the girl child sexual offenses. We are dealing in the court, which is very, very important and vital evidence collected by the evidence. Now, slowly the Honorable Supreme Court and all the high courts are they are conscious of the fact that we have to give importance and make it a admissible evidence as far as possible given legal framework. So one amendment I have highlighted, that section 53 capital A introduced about in the year 2005. The courts are now taking into consideration, and although it is challenged in every case by the accused persons, but it is held that it is a negative as well as positive evidence. Because if it is positive, then it will help the prosecution, the victim. If it is negative, then it will help the accused. The offender can be taken advantage of that DNA is not matching collected from the victim or victim clothes. So it is double-edged weapon, we can say, DNA test. But generally, the accused person, they oppose, they take advantage of the law which is prevailing, that one can't enforce to give blood test. So earlier you can remember N.D. Tiwari's case where paternity dispute, but now slowly it is developing. Now court in if feels that it is necessary for fair trial and justice, then court can give directions for DNA test. So in this brief, I try to share my view and little knowledge.
Thank you so much, sir. Thank you, sir, for your thought-provoking address, which was based on real case studies.
Only because it is consulting with the court cases.
Yes, sir. Now, participants, if having any question, please raise your hand. I think each and everything is clear to participants.
Thank you. Thank you.
Now I request Dr. M.P. Gautam sir for his concluding remark. Gautam sir?
Okay.
Yes.
Joining. First of all, I would like to thank Shri Sanjay Kumar ji, a very senior person who is associated with the judicial system since long back. He is having a great knowledge about the Indian Evidence Act and what was the need of this present era. He has especially extracted that one because regarding the 45 section, this provision was not there, but he has especially chosen this topic, which is very much be informative to our faculty. He has explained very nicely the provisions of 65 Indian Evidence Act, their interpretations also, and admissibility of the electronic evidence. He has also given some information regarding the directions of the Honorable Supreme Court. Certification of the evidence in which conditions, when there is a secondary evidence or primary evidence. He has also given some important case mentioned about the Arjuna Pandita case. In general, it is a general impression that the forensic evidence, physical evidence are supposed to be a secondary evidence. But how nicely our speaker has told about the document, because the documents are considered as a primary evidence. And regarding the digital evidence, he has very clearly explained how this can be obtained from the concerning department. And after that, it is produced before the court, and now it is considered as a relevant and considered as an evidence. He has also given some idea about the expert evidence, percipient evidence, and so on. But he especially focused on the digital evidence because now the time has changed. It is the need of this thing. I am extremely thankful to Sri Sanjay Kumar ji, a very learned speaker I found him. And I hope that in future also, whenever we will request to you, you will not deny, I hope. Thank you very much.
Thank you. Thank you. Thank you very much for giving me this opportunity for interaction.
Swati.
Thank you so much, sir, once again. It's our pleasure.
Thank you.
Now,
thank you. Thank
now
you.
we can leave now.
Yeah.
No, sir.
Oh.
Sir, now is the time of valedictory session. Sir, it's our honor if you connect with us. Ji Sanjay, sir.
Okay.
Yes, very good, very good. So now the chief guest of this session will be the Sri Sanjay Kumar.
Yes, sir. Yes,
very
sir.
good. It is our fortunate.
Yes, sir. Now, moving towards the end of the program, I present the brief report of FDP 2022. The criminal justice system is becoming more effective, adaptive, and efficient with the advancement in crime prevention and crime detection. Therefore, the FDP aims to facilitate faculty members, research scholars, lawyers to strengthen their knowledge in the field. In the very first day of FDP, inaugural session began with virtual lamp lighting ceremony as tribute to Ma Saraswati. Chief guest of the inaugural ceremony was Dr. G.S. Bajpai, Vice Chancellor, Rajiv Gandhi National University of Law, Punjab. Opening remark of the theme was highlighted by Dr. M.P. Gautam, advisor of FDP 2022. Honorable Vice Chancellor Dr. Upendra Dhar welcomed the August gathering, and in his welcome address, he highlighted that FDP is continuous process. Unless efforts are made to develop faculty continuously, transfer of knowledge from faculty to student cannot happen. He informed that National Education Policy 2020 has also very significantly stressed on the importance of faculty development. The chief guest on the occasion, Dr. G.S. Bajpai, Vice Chancellor, Rajiv Gandhi National University of Law, Punjab, explained the role of criminal justice system. He said that the criminal justice is considered to be the barometer of the civilization in any society. In that sense, criminal justice is also the inspiration of progressive society. The performance of criminal justice system has severe implication to the state of happiness in the society. The inaugural session concluded by Dr. Ashutosh Shukla, program convener, by proposing words of thanks. In this FDP, total 11 lectures were delivered by experts. In first day on 23rd August, Dr. Abha Singh, Director, PSYFI Solution Private Limited, Noida, and Dr. Sandeep Gupta, Scientist E, Wildlife Institute of India, Dehradun, had delivered the lecture on Psychology of Micro-Expressions and Advancement in Wildlife Forensics, respectively. Mrs. Nandini Bansor and Mr. Nirvan Ingole, Assistant Professor of Sri Vaishnav Institute of Forensic Science, were the moderator of the sessions. In second day of FDP on 24th August, lectures were delivered by Dr. Arvind Tiwari, Dean, School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, Mumbai, and Dr. Shalini Gupta, Professor, Department of Oral Pathology and Microbiology, in charge, Forensic Odontology Unit, KGMU, Lucknow, on correctional justice and advancement in the field of forensic odontology, respectively. Mr. Dinesh Kamble and Mrs. Poonam Yadav, Assistant Professor of Sri Vaishnav Institute of Forensic Science, were the moderators. There were 3 lectures scheduled on 25th August in third day of FDP. Dr. Anupma Raina, Scientist 2, Division of Forensic Pathology and Molecular DNA Laboratory, AIMS, New Delhi, was delivered lecture on Role of Molecular Biology Technique in Criminal Justice. The topic Recent Advances in Fingerprint Analysis is covered by Dr. Mukesh Kumar Thakkar, Professor and Head, Department of Forensic Science, Punjabi University, Patiala. On same day, Dr. Devashish Bose, Professor and Head, Department of Criminology and Forensic Science, Dr. Hari Singh Gaur, Central University, Sagar, Madhya Pradesh, was beautifully explained about the recent advancement in the criminal justice system. Ms. Ashna Pathak, Mrs. Nandini Bansor, and Mr. Dinesh Kamble, Assistant Professor of SBIFS, were the moderator of that sessions. In fourth day on 24th August, lectures were taken by Dr. Mohammad Vilayat Khan, Professor Forensic Medicine and Toxicology, Delta Medical College, Dhaka, Bangladesh, and S. Vinita, Additional Judge and Faculty at Madhya Pradesh Judicial Academy, on the topic Medical Ethics and Expert Testimony, respectively. The moderators of the session were Mr. Nirvan Ingole and Mrs. Poonam Yadav. Today, on last day of FDP, we have listened to Dr. Santosh, Vice President, Digital Forensic and Incident Response, ESEC Code Technologies, and Sri Sanjay Kumar, Principal District and Session Judge, West, 30 Hazaripur, Delhi, on digital forensic challenges with case study and admissibility of electron evidence in DNA profiling in court of law, respectively. Ms. Archana Pathak moderated the session. Ms. Hiramani Patidar and Mr. Ayush Verma, lab instructor of Sri Vaishnav Institute of Forensic Science, provided all necessary assistance during the program. The FDP had an overwhelming response as 62 participants had registered from various institutions across the India like Dr. Hari Singh Gaur Central University, Sagar, Madhya Pradesh, Government Holkar Science College, Indore, Madhya Pradesh, Medicaps University, Indore, Madhya Pradesh, Modern Dental College and Research Center, Indore, Madhya Pradesh, Indore Institute of Law, Vikram University, Ujjain, Ravindranath Tagore University, Bhopal, Barkatullah University, Bhopal, Mangalayatan University, Jabalpur, National Forensic Science University, Gandhinagar, Jharkhand Raksha Shakti University, Ranchi, Government Institute of Forensic Science, Nagpur, Maharashtra, Government Institute of Forensic Science, Mumbai, Maharashtra, Jain Deemed to be University, Bengaluru, Suresh Gyan Bihar University, Jaipur, Satyabhama School of Law, Satyabhama University, Chennai, Kalinga University, Raipur, Lovely Professional University, Punjab, Periyari University, Tamil Nadu, Karnataka Science College, Dharwad, Coronia University of Technology and Science, Coimbatore, MET University, Noida, Symbiosis Law School, IPEM Law Academy, Ghaziabad, Punjab University, Punjab, Chandigarh University of Business, Mohali. Last but not the least, Sri Vaishnav Vidyapeeth Vishwavidyalaya, Indore. The program came to an end with a note that learning never exhausts the mind. Thank you. A, B, C, D, E, F. What do you think? Here I am teaching you alphabets. No. I want to say that the shortest word of English that contains letter A, B, C, D, E, F is feedback. Feedback is the soul of any program and participants are the backbone of any program. Now, may I request participants to please raise the hand for proposing feedback. Yes. Are you, sir?
Yes, ma'am. There is one Shivani Solanki. Shivani,
Yes.
please unmute yourself.
Please allow her as panelist
Yes, ma'am.
so she can able to open the camera also.
Yes, ma'am. Yes, please switch on your camera.
Good afternoon, everyone. Ma'am, I am audible.
Yes, yes, you are audible, Shivani.
Yeah, good afternoon. I am Shivani Solanki from Government Holkar Science College. I want to thanks to Sri Vaishnav Institute of Forensic Science for place all wonderful ideas together by organizing this program on recent advancement in the criminal justice system. The whole session was very knowledgeable and thanks to all speakers to enlighten us by sharing their valuable knowledge. Thank you so much.
Thank you so much, Shivani. Any other participant? Okay. Now, no duty is more than urgent than giving the thanks. Now, I request Dr. MP Gautam to kindly propose words of thanks.
At the outset, I would like to thank our chief guest of this FDP program, Dr. G.S. Bajpayee, Honorable Vice Chancellor, Rajiv Gandhi National Law University, Patiala, for accepting our invitation and providing a very informative and valuable lecture on criminal justice system and its significance. I am also thankful to Dr. Upendra Dhar, Honorable Vice Chancellor Sri Vaishnav Vidyapeeth Vishwavidyalaya, Indore, for his continuous motivation and encouragement throughout the course of this program. I am also thankful to Dr. Asutosh Shukla, coordinator of Forensic Science Institute, for his support and help. I am also thankful to all the faculty members of this institute, Mrs. Nandini Banswar, Nirmal Ingole, Mr. Dinesh Kamble, Mrs. Poonami Yadav, Miss Archana Pathak, Miss Hira Mani Patidar, and Mr. Ayush Barwa for their support every time, wherever needed, in all means. I am also thankful to all the participants who took the interest in this, and I hope that they might have gained a knowledge about the this criminal justice system and as a forensic scientist, which kind of responsibilities has to be hold upon whenever you will become you will be in any service, either in a government service or in the private sector. But lastly, but not the least, I am also thankful to Dr. Swati Dubey Mishra, who took pains. I have seen her work, very hard work she has done. She has contacted the various speakers, and as a result, we have found that this program is a great success. Thank you.
Thank you, sir.
One more thing. I am also thankful to the technical team of this our SPPB. Without their help, it could not have been happened as it is
Online,
looking
yes,
online. Thank you, technical team.
Thank you, sir. No matter how difficult the challenge is, when we spread our wings of faith and allow the wind of God's Spirit to lift us, no obstacle is too great to overcome. Now, I request everyone to please on the camera for taking the witness of this program. Are you, sir? Please take the snapshot.
Yes, ma'am. Yes, ma'am. Take it.
Thank you, everyone. At last, now I request everyone to please stand up for national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you, everyone. I hope we will meet again in our next FDP 2023. Thank you so much, sir. Sanjay sir. Thank
संजय
you.
कुमार जी नमस्कार, फिर मुलाकात होगी अगले प्रोग्राम में।
Yes, sir.